Welcome to Literary and Jury Charge Practice. Let's get started with some jury charge, and the subject of this jury charge is double indemnity. Ready? Gentlemen of the jury, you are instructed that in this case the burden of proof rests upon the plaintiff to prove the material allegations of her petition by the fair preponderance of the evidence, and if she has failed to do this, your verdict should be for the defendant. By the fair preponderance of the evidence is not meant necessarily the greater number of witnesses, but it is that proof which satisfies your mind as to its truth when weighed against the evidence received in opposition thereto. There has been introduced the testimony of certain witnesses who purport to be skilled in their line of endeavor. Such witnesses are known in law as expert witnesses. An expert witness is one who is skilled in any certain art, business, or profession, possessed of peculiar knowledge required by study, observation, and practice. You are instructed that you may consider the testimony of these witnesses and give it such weight and value as you think it should have, but the weight and value to be given their testimony is for you to determine. You are not required to surrender your own judgment to that of any person testifying as an expert, or give controlling effect to the opinion of an expert, for the testimony of an expert, like that of any other witness, is to be received by you and given such weight and value as you deem it is entitled to receive. You are instructed that it is the sole province of the jury to form conclusions from expert testimony as to the existence of particular facts not of common knowledge and peculiar within the knowledge of men whose experience enables them to speak with authority, and to weigh such testimony as given by them to arrive at a decision as to whether the deceased came to his death as a result of a fall or accident, or whether he died from a heart condition. You are instructed that the fact that the deceased had a weakened condition of the heart did not in itself preclude the plaintiff from recovery, and if you find and believe from the evidence that the deceased received a fall which accelerated the condition of the plaintiff to such an extent that death resulted, it was an accidental death within the meaning of this policy. You are instructed that the beneficiary or the plaintiff in this case has filed suit under the double indemnity clause of a life insurance policy which was admittedly issued by the defendant, that under the double indemnity clause upon which this suit is founded, providing that double amount of the face of the policy be paid in case of accidental death, the statement of the person or physician who prepared the proof of death is merely a conclusion of that party and was made only for the purpose of establishing the manner in which he died. You are instructed that if you find and believe from the evidence that the deceased fell, and as a result of that fall he received a severe blow on the head, which accelerated or aggravated a diseased condition which was present and had been present for some time, and that death resulted therefrom, it was an accidental death within the meaning of this policy, and your verdict should be for the plaintiff. Now for some literary practice. And this This art is actually an article, and it's called A New Cart Provider's Journey. And we will continue with this article now. Ready? 6. Know your software. You've heard it a million times, but there's a reason for that. Setting up phonetic translation and being able to manipulate your display, for example, are crucial. 2 minutes before class started one day, my client asked me to change my text color, background color, and text size. It should have been simple, but there were unexpected problems, such as the black background causing my include files to be invisible since they were programmed with black text. Then my headers turned on unexpectedly, causing huge jumps in my display. It was just a mess. That day still haunts my dreams. 7. Get a mentor, or get two, as I did. I've bothered these wonderfully patient women with panicky questions on such topics as wardrobe, taxes, salary negotiation, and even wedding reception locations. Obviously, we became friends. I should not suggest beginning your relationship with wedding-related questions, but consider yourself lucky if it ever does go there. 8. Read up on CART ethics and guidelines. You know all those lovely codes you're responsible for knowing as a certified court reporter. There's a whole different set of rules for CART, and issues such as confidentiality and client sensitivity are a big deal. NCRA's website is a good place to start. 9. Get certified. No, it's not necessary, and I know some phenomenal writers who aren't, but it helps to get your foot in the door, gives you more options, especially during school breaks when jobs are scarce, and covers you if employers ever decide to start requiring it. As a bonus, someone usually wants to throw you a party. 10. Build your dictionary like crazy and know it well. I know reporters who started taking depositions with fewer than 20,000 entries, but I don't think that would work in CART. That being said, prefixes and suffixes are imperative and allow you to create significantly more words than entries. So it's not as hard as it may seem to have a functioning dictionary. I practice to anything I can get my hands on. Newspapers, books, magazines, podcasts, my little sister's textbooks, and lists of names. This will help you get used to writing unfamiliar words. You know what I've never written on the job? Beyond a reasonable doubt. And that is the end of that literary. Now let's get back to some jury charge practice. Ready? You are further instructed, however, that if you do not find and believe from the evidence that the deceased fell, and as a result of that fall he received a severe blow on the head, which accelerated or aggravated a diseased condition which was present and had been present for some time, and that death resulted therefrom, it was not an accidental death within the meaning of this policy, and your verdict should be for the defendant. You are instructed that if you find from the evidence in this case by a fair preponderance thereof that Thomas Doolittle came to his death from an occlusion of the heart which resulted directly and independently from all other causes, and solely because of a fall which he received, and under the conditions have been testified to, that the occlusion of the heart and his consequential death was a result unexpected, unforeseen, and involuntary, then it will be your duty to find in favor of the plaintiff and fix her recovery against the defendant in the sum of $6,000 under the double indemnity clause quoted in the policy in controversy. You are the sole judges of the credibility of the witnesses and the weight and value to be given to their testimony. If the testimony of a witness is apparently candid and fair, reasonable within itself, and such witness has been in no way impeached, you should not arbitrarily discard each testimony. It is your duty to reconcile the testimony if you can, so it may all stand. If you cannot reconcile the testimony, then for the purpose of ascertaining what testimony is worthy of credit, you may take into consideration the apparent candor and fairness of a witness, the reasonableness or unreasonableness of his or her story, whether or not the witness has been in any way impeached, the interest of the witness, if any, in the result of the trial, the opportunities or lack of opportunities of the witness to see or hear or know the things about which he testified, whether or not any witness has made contradictory statements, and all the circumstances surrounding the case. If, after a careful consideration of all the evidence in the case, you find that any witness or witnesses have knowingly, willfully, and corruptly testified falsely to any fact material to the issues in the case, you have a right to entirely disregard his or their testimony, or any part thereof, as you may deem proper. You should consider these instructions as a whole, and you should not reach a verdict based on any single instruction. In arriving at your verdict, you must be governed solely and alone by a consideration of the evidence and the instructions of the court. Your verdict should not be reached by casting lots, striking an average, or by any manner or species of chance. 9 or more of your number may return a verdict in this case, and in the event your verdict is not unanimous but 9 or more, less than all, agree upon a verdict, then those agreeing should sign the verdict. In the event your verdict is unanimous, it should be signed by your foreman and returned into court. Forms of verdicts will be submitted to you for your consideration. All right, let's see what we have here as far as some literary material. Let's try this article. It's called MD versus DDS. See what that's all about. Ready? It's by Jean Bettler, B-E-T-L-E-R. Ready? Imagine, if you will, that you have an appointment with your dentist for a routine cleaning. A few days before, you begin to feel symptoms of the flu, and as the day of your appointment comes closer, you continue to feel worse. Why don't I have the dentist treat my flu symptoms? After all, the dentist and the medical doctor are both in the healthcare industry, and they both can give me prescriptions for antibiotics and painkillers. And to top it off, they are both working towards the same goal, a healthier me. This idea just gets better and better the more that I think about it. After all, think of all the money I will save by eliminating the cost of one of the professionals who really isn't needed. At least those were my thoughts before my appendix burst a few days later, and I was rushed to the emergency room. While the above story is just fiction, a very similar story happens every day in our industry. We all have heard of the court reporting firm across town that sends a court reporter out with a video camera, or the legal video firm that tells the attorneys, "You don't need a court reporter, we can do it all." Even a vendor in our industry states to each of us that by using their product, there is no need for the other professional. So why do we need both a court reporter and a legal videographer at a deposition? Like the medical doctor and the dentist, we both have different skills and training that are unique to our professions. And after all, do you really want your child's pediatrician pulling out your baby's teeth? Legal videographers bring professional video and audio gear to the deposition and set up portable studios, checking and troubleshooting everything before everyone arrives. They ensure that the deposition is recorded in accordance with the rules governing the event, part of which is ensuring that no bias is introduced into the final product, either accidentally or on purpose. Along with continuing to evaluate the video, they are constantly adjusting the audio to ensure uniformity of the levels throughout the deposition and to reduce or eliminate unwanted environmental noises. In today's world, videographers must also be able to deliver video in a host of formats and using multiple delivery methods. All right, we will get back to that article. For now, let's try this jury charge. And this subject of this jury charge is drainage ditch. Ready? Here we go. The undersigned owners and or resident owners of the land hereinafter described respectfully represent as follows, that the establishment of a drainage ditch along the route hereinafter specified will be of public benefit and utility, will promote the public health, and is necessary for the following reasons, to wit, that the reclamation of wet and overflowed lands requires the construction of drainage ditches, that the lands along said proposed ditches are fertile and valuable farm lands, either too wet for farming or often flooded by surface water, destroying growing crops and causing inconvenience in farm operations, that water often collects along the route and becomes stagnant, foul, and polluted, creating breeding places for mosquitoes and other disease-bearing insects, thereby endangering the health of persons living in the vicinity thereof, and that the public highways are often flooded or washed out, causing inconvenience to the traveling public and damage to the highways, requiring extensive repairs. That the general description of said proposed drainage ditch is as follows, to wit, commencing at a point 400 feet north of the west corner of Section 3, Township 111 North, Range 41 West, Marshall Township, in the town of Lakewood in the county of Cook, thence running along the following route. northeasterly through said section 3, crossing the North Township line 400 feet east of the north corner of section 3, thence northeasterly through section 34, Township 112 North, range 41 West, Lyons Township, crossing the east line of section 34, 600 feet south of the east corner of section 34, thence about 240 rods easterly into section 35, Township 112 North, range 41 West, Lyons Township, thence northerly about 150 rods, and thence easterly about 100 rods, and terminating on the east line of section 35 at a point approximately 600 feet south of the northeast section corner of said section 35. All right. And we will stop there. And that will conclude our literary and jury charge practice.